We have talked to people connected with the governor's office and are told that they are expecting within days a petition, presumably for clemency. Is this something that you're actively looking at right now?
I don't know when this airs, but you can be sure that days is not accurate. Number one. Number two, there is a podcast that the governor dropped over the weekend. I'd invite anybody to take a listen to it.
So
So
you
it's not
are
like hours.
you are asking for clemency today. You're filing something today.
We have dual tracks. I am doing everything possible. I've said publicly, I want them home, not just for Thanksgiving, but for Joan's 93rd and to celebrate with Aunt Terry as well.
We checked with the court. They said they're probably not going to do the hearing this month. It would be next month because there's a jury trial going on. So the other path is the governor. So have you been in touch with the governor, or is this just documents you're filing today?
I'm not going to comment on that. I'll just say that by the time this airs, we'll be on that path.
The DA is asking for resentencing, which would require the parole board to ultimately hear the case. That could take a long time, and you don't know what they're going to do. There is another path. I looked at this law. You could go into court and say, look, even though you're asking for resentencing, the DA is asking for resentencing, what we think the judge should do is change the conviction from murder to manslaughter in the interest of justice, because that's what the law would allow under certain cases. And that if the judge would do that, they'd instantly be free men because the maximum sentence is 11 years. They've served 35. We contacted the DA's office and they said, even though they're asking for resentencing, they would be open to this argument of changing the conviction. Are you going to make that argument in court?
For anybody who has been paying attention, I've been saying all along that the biggest hurdle here is to get a DA initiating the resentencing, which the DA has now done. We are now free to argue to the judge, look, Your Honor, based on this record, based on the law, just follow the law, you can and you should recall this sentence. You should reduce the murder conviction to a voluntary manslaughter. The voluntary manslaughter has a 369 plus 2, or if it was 11, and then 1/3 of the midterm. I won't get into the calculations. They've done more than the maximum that was available at the time under the California law. And as you said, Harvey, that would not necessitate going to a parole board. You know, one of the problems with going to a parole board, and I've successfully won parole board hearings, but it's not from the client's problem. It's why put the family, who in many cases, as I mentioned, is either in ill health or at a ripe old age, through the trauma of revisiting all of this family drama, and not once, but twice, both for Lyle and for Erik in parole hearings. They've more than served ample amount of time. I've said it a million times. It's almost become cliche. If they were the Menendez sisters, they wouldn't be here. They had more jurors vote for manslaughter than murder when the abuse was presented in trial the first time, and it's time now for them to be released.